everyone. Welcome to yet another day, another lecture on administrative law. We have been discussing administrative law for quite some time now. In our last lecture yesterday, we tried to understand the reasons at the end. We tried to understand the reasons for the growth of administrative adjudication. All the reasons we tried to understand, which brought forth the growth of administrative adjudication. We tried to understand that. We tried to understand how the complexity of modern governance made it mandatory for administrative adjudication to arise, how overburdened courts gave rise to administrative adjudication, how the need for speed and efficiency gave rise to administrative adjudication. We tried to understand how the need for specialized expertise with in the adjudication process gave rise to administrative adjudication. We tried to understand all of that in our last lecture yesterday. So today we're trying to understand, let's begin by understanding the advantages of administrative adjudication. Let's start with that. Let's try to understand now what are the advantages that administrative adjudication has to offer. So it offers several advantages, and that's why it was adopted. First and foremost is the speed. Speed being one of the first and the foremost advantages of administrative adjudication. We understood in the very beginning of yesterday's class how there was a need when the courts were overburdened to speedify justice, to speed it up. So in that context, administrative adjudication emerged, and administrative adjudication in fact does that very perfectly. It gets speed into the adjudication process. So tribunals often resolve the disputes quickly than the ordinary courts. Another advantage that administrative adjudication has is it brings in expertise. It brings in expertise, specialized adjudication, like we talked about the income tax tribunals, we talked about TRAI, Telecom Regulatory Authority of India, we talked about SEBI, the Securities and Exchange Board of India, all these being very technical in their nature. So it brings in specialized adjudication process, the technical knowledge into these regulatory sectors. Another advantage is the procedural simplicity which administrative adjudication brings in. The procedural simplicity. Normal ordinary courts में जो procedures lay down है, which the Constitution has empowered the courts to frame their own procedures. So they regulate their own procedures, their own businesses, and they have to follow the due process of law. In comparison, administrative adjudication, the process of adjudication by the administration, it is not as rigid as is the case of ordinary courts. So they're not, although they follow the principles of natural justice, they are not bound by any procedures. They can formulate their own procedures, and that makes them more or less flexible as compared to the ordinary courts. So this procedural simplicity becomes an advantage of administrative adjudication. It involves simple procedures. This makes dispute resolution more accessible. Another important advantage is it reduces the burden on the courts. Administrative adjudication came into being because of courts being overburdened. And what it intends to do is it intends to reduce the burden of the courts. So the courts which would otherwise have to hear these disputes, now administration hears these disputes. Although the appeals from the administrative courts can lie with the ordinary courts, not vice versa, which we have discussed in our last lecture. Our appeals from the administrative courts can lie in the ordinary courts, but appeals from the ordinary courts cannot lie in the administrative courts. The single, unified, separate judiciary in India maintains its separation in that aspect, so that there is no indulgence, there is no interference from the executive or the legislative part of the government. So these are the advantages of administrative adjudication. Now it has certain limitations and there are certain concerns. Let's try to understand the limitations and the concerns. Now let's try to understand the limitations and the concerns. Despite its advantages, administrative adjudication raises several concerns, because by its nature, it is going against certain things, certain established norms, certain established principles. It's going against them. Adjudication traditionally was the domain of ordinary courts, and now we're going far beyond that, and we're giving this adjudication power to the bureaucracy. So there are concerns, and let's try to understand them now. So the first and the foremost being the risk of the executive bias. Risk of the executive bias. Now, when you're giving power to the executive, to the civil services under administrative laws, administrative adjudication, in that aspect, you're taking the established lawmaking power, which was established adjudication power, adjudicating powers originally entrusted to the ordinary courts. You're taking that away from there, and you're making administration do it. So there's always a risk that the executive will be biased. Although we said that it follows the principles of natural justice, we talked about the principles of natural justice in our last lectures. We tried to understand, remember the second principle of natural justice which I taught you, that no one shall be a judge in his or her own case. That is the second PNJ. कोई अपने केस में जज नहीं होगा. Now, keep that principle in mind, and now look at administrative adjudication. Under administrative adjudication, the administration is adjudicating cases against itself. Citizen against the administration, citizen against the bureaucracy. So there is a chance that PNJ 2 would be violated because administration is being a judge in its own case. So that gives rise to the risk of executive bias. So there is a risk of executive bias, right? Since administrative adjudication operates within the executive branch, questions may arise about their independence, how independent they are. See? So that's a big risk and the biggest risk. Then another concern is the limited procedural safeguard. Limited procedural safeguards. Administrative procedures, they may sometimes lack the procedural safeguards which are available in traditional courts. Just now when we were trying to understand the advent of administrative, the advantages of administrative adjudication, हमने बस अभी समझा था कि एक important advantage इसका है over the traditional courts कि ये administrative adjudication जो है ये flexible है in its approach क्योंकि ये bound नहीं है by the procedures that the traditional courts are used to, they are bound by. But having said that, that should also raise certain concerns, and the concern is that these limited safeguards which they follow in the pursuit of flexibility, ये जिन norms को, ये जिन procedures को follow करते हैं, वो safeguards वो traditional courts में available नहीं है. वो procedural safeguards जो हैं वो malign कर सकते हैं, speediness के चक्कर में justice को hinder कर सकते हैं. So that is a potential concern. Then there's always a potential for abuse of power. Potential for abuse of power. So there's always this potential for abuse of power because without proper oversight, administrative adjudication could lead to arbitrary decisions being made. And this arbitrariness in decision making is going to hinder the very democratic norms. In that aspect, this abuse of power has to be checked because there is a potential of abuse of power happening in case of administrative adjudication. Okay. Now, let's try to understand the administrative adjudication in the Indian context. Administrative adjudication in the Indian context. India has developed a very extensive system of administrative tribunals. Okay, these tribunals handle disputes on a wide range of issues. Issues like from taxation to labor reforms, communications, service matters, environmental concerns. So in the Indian context, we see a wide range of wide array of tribunals that we have formed, not limited to, but extensively over taxation, over labor reforms, communications, service matters, environmental concerns, all of that. Constitution itself recognizes the importance of tribunals. The 42nd Constitutional Amendment Act, 42nd Constitutional Amendment Act. This 42nd Constitutional Amendment Act, which happened in 1976, it introduced Article 323A. It introduced the Article 323A and 323B into the Constitution. So it is because of this 42nd Constitutional Amendment Act. And these articles allowed the formation, the creation of administrative courts, which are called the tribunals. And these tribunals now function as specialized adjudicatory bodies, adjudicating disputes under the administrative framework. So now you will have to realize and understand that administrative adjudication represents a very important innovation in modern governance. It reflects the realities that modern states require specialized mechanisms for dispute resolution. Specialized mechanisms. Okay. However, you will also have to bear in mind that administrative adjudication must always remain consistent with the fundamental principles of administrative law, including natural justice, both PNJ 1 and PNJ 2, fairness, accountability, judicial oversight. They should always remain subject to it. Because if they are not remaining subject to it, then there is a real chance of abuse of power happening because of administrative adjudication. There's a real chance of degradation of the democratic structures happening because of administrative adjudication. So, eternal vigilance is the price of liberty. So, a system has to be eternally vigilant because that is the price it has to pay to for its freedom that it has gotten. So administrative adjudication represents this critical institutional response to the complexity of modern governance. By combining the administrative expertise with adjudicatory functions, ये गवर्नमेंट्स को अलाउ करता है रिजॉल्व करने के लिए डिस्प्यूट्स एफिशिएंटली while maintaining the regulatory oversight at the same time. ये वो इनोवेशन है जो वो कर रही है. लेजिटिमेसी एडमिनिस्ट्रेटिव एडजुडिकेशन की डिपेंड करती है मेंटेन करने पे फेयर प्रोसीजर्स. जितना वो फेयर प्रोसीजर्स मेंटेन करेगा उतना वो लीगल है, उतना वो लेजिटिमेट है. जितना वो इंडिपेंडेंस और जुडिशियल रिव्यू को फॉलो करेंगे और उसके कॉन्टोर्स के अंदर काम करेंगे उतना वो लेजिटिमेट है. जितना एडमिनिस्ट्रेटिव एडजुडिकेशन, जुडिशियल रिव्यू, ओपननेस और फेयरनेस इन चीजों से दूर जाएगा, इन दो चीजों से टकराएगा, उतनी उसकी लेजिटिमेसी कम होगी. इसीलिए एडमिनिस्ट्रेटिव लॉ इंश्योर करता है दैट एडमिनिस्ट्रेटिव एडजुडिकेशन ऑलवेज ऑपरेट्स within the framework of constitutional governance and within the framework of the rule of law. Get it? So now let's delve a little bit deeper into the tribunals in India. Okay. अभी तक हमने प्रीवियस लेक्चर से लेके अभी तक हमने समझा कॉन्सेप्ट ऑफ एडमिनिस्ट्रेटिव एडजुडिकेशन, प्रोसेस जिससे एडमिनिस्ट्रेटिव एजेंसीज रिजॉल्व करती हैं डिस्प्यूट्स थ्रू दिस क्वाजी जुडिशियल मैकेनिज्म। अब इस इंस्टीट्यूशनल मैकेनिज्म का मैनिफेस्टेशन, इस कॉन्सेप्ट का मैनिफेस्टेशन इंडियन कॉन्टेक्स्ट में आप समझने की कोशिश करते हैं। इंस्टीट्यूशनल मैनिफेस्टेशन ऑफ एडमिनिस्ट्रेटिव एडजुडिकेशन। ट्रिब्यूनल्स इंस्टीट्यूशनल मैनिफेस्टेशन है एडमिनिस्ट्रेटिव एडजुडिकेशन का इंडियन कॉन्टेक्स्ट में। ठीक, ट्रिब्यूनल्स जो है वो फॉर्म करते हैं ये क्रूशियल कंपोनेंट ऑफ इंडियन एडमिनिस्ट्रेटिव जस्टिस सिस्टम। एडमिनिस्ट्रेटिव जस्टिस सिस्टम, not the ordinary justice system, which is the courts. Tribunals in Indian context are, they represent the administrative justice system. ये ऑपरेट करते हैं इन स्पेशलाइज्ड एरियाज लाइक सर्विस मैटर्स इनका ऑफ गवर्नमेंट एम्प्लॉइज, service matters of these government, so they indulge themselves, they are concerned with service matters of these government employees, taxation disputes, environmental protection. So the tribunals in India are concerning themselves with consumer protection, इसीलिए ट्रिब्यूनल्स को समझना एक्सट्रीमली इंपॉर्टेंट है क्योंकि ये रिप्रेजेंट करते हैं एक मेजर शिफ्ट ट्रेडिशनल जस्टिस डिलीवरी सिस्टम में। ट्रेडिशनली द कोर्ट्स वर रिस्पॉन्सिबल फॉर they were responsible for administering justice, adjudicating disputes, but now under administrative adjudication there's this all new shift from the traditional to something much different. इसीलिए इसको समझना इंपॉर्टेंट बन जाता है। ये दिखाता है कैसे मॉडर्न गवर्नेंस इंटीग्रेट करती है एडमिनिस्ट्रेटिव एक्सपर्टीज को एडजुडिकेटरी फंक्शंस में। ठीक, तो ट्रिब्यूनल है क्या? ट्रिब्यूनल एक क्वाजी जुडिशियल बॉडी है। It's a quasi judicial body. Fully judicial नहीं है, it's a quasi judicial body which is established by law. पेरेंट लॉ कोई है उसने बनाया है एडजुडिकेट करने के लिए डिस्प्यूट्स स्पेशलाइज्ड एरियाज में, इन द स्पेशलाइज्ड एरियाज। सो ये क्वाजी जुडिशियल बॉडी है जिसको किसी पेरेंट लॉ ने बनाया है एडजुडिकेट करने के लिए डिस्प्यूट्स को स्पेशलाइज्ड एरियाज में। Unlike ordinary courts, tribunals are by its very nature designed to provide specialized expertise. So they provide number one, they provide specialized expertise. Let's say, for example, service matters, there's a certain level of specialization which is required. Taxation matters, there's a certain level of specialization which is required, so on and so forth. So, ये specialized expertise provide करते हैं, ये simplified procedures, so they provide, tribunals in India provide these specialized expertise, simplified procedures, and faster dispute resolution. And faster dispute resolution. ठीक, ट्रिब्यूनल्स इसीलिए कभी कभी डिस्क्राइब किए जाते हैं एज ऑल्टरनेटिव एडजुडिकेटरी मैकेनिज्म्स विद इन द एडमिनिस्ट्रेटिव स्टेट, क्योंकि ये परफॉर्म करते हैं जुडिशियल फंक्शंस जो नहीं है पार्ट ऑफ द नॉर्मल ऑफ द ट्रेडिशनल जुडिशियल हायरार्की, दे परफॉर्म दोज फंक्शंस। एडमिनिस्ट्रेटिव लॉ के जो स्कॉलर्स हैं वो ट्रिब्यूनल्स को डिफाइन करते हैं एज बॉडीज क्रिएटेड बाय द स्टैट्यूट्स that exercise judicial or quasi-judicial powers in specialized areas of the law. You should write this. Scholars of administrative law describe describe tribunals as bodies created by statutes that exercise judicial or quasi-judicial powers in specialized areas of the law. ये जो tribunals होते हैं, they generally have they have the authority, they possess the authority to hear disputes, so they hear disputes. ट्रिब्यूनल्स डिस्प्यूट सुनते हैं, एग्जामिन करते हैं एविडेंस को, एग्जामिन एविडेंस, ये एविडेंस मंगाते हैं, एविडेंस सुनते हैं, एविडेंस से मतलब निकालने की कोशिश करते हैं, इंटरप्रेट करते हैं स्टैट्यूट्स को, कानून क्या कहता है ये उसको इंटरप्रेट करते हैं एडमिनिस्ट्रेटिव कोर्ट्स, और ये इशू करते हैं डिसीजंस जो बाइंडिंग होते हैं। सो दे इशू बाइंडिंग decisions. ठीक, but one thing has to be remembered, their binding decisions, the decisions in general, they're subject to the judicial review of the courts. So इनका decision जो है, that's always subject to the judicial review by the ordinary courts. ये जो tribunals का concept है इंडिया में, it existed even before independence. मगर tribunals gained prominence after independence due to the expansion of administrative governance. क्योंकि आजादी के बाद we embarked upon welfare orientation, so the government was formed which was welfare oriented, and it was a socialistic form of government more or less. So it engaged in each and every venture of human endeavor. So in that aspect bureaucracy भी फैल गई और disputes जो है वो भी बढ़ने लगे और tribunals की growth जो है वो हमें देखने को मिली. Traditional courts face कर रहे थे workload, delays. As a result, government जो है it began establishing specialized tribunals. So हमें आजादी के बाद और ज्यादा नजर आते हैं इनका स्प्रिंगिंग और इनका फैलना. ये ट्रेंड एक्सेलरेट हुआ significantly in 1970s and 1980s. ठीक है, कॉन्स्टिट्यूशनल बेसिस जो ट्रिब्यूनल्स का है वो मैंने आपको अभी समझाया था. When the 42nd Constitutional Amendment Act of 1976 was passed, ये कॉन्स्टिट्यूशनल बेसिस बनाया ट्रिब्यूनल्स का इंडिया में. ठीक, जो अमेंडमेंट था इसने इंट्रोड्यूस किया 323A और 323B. ये प्रोविजंस ने ऑथराइज किया एडमिनिस्ट्रेशन को एस्टैब्लिश करने के लिए एडमिनिस्ट्रेटिव ट्रिब्यूनल्स को स्पेशलाइज्ड एरियाज ऑफ गवर्नेंस के लिए. आर्टिकल 323A जो है ये एम्पावर करता है. So Article 323A, it empowers the Parliament to establish tribunals for the adjudication of service matters of public servants. ये जो हमने अभी देखा था किस चीज के लिए बनते हैं ये, for labor reform. So it's a form of labor reform. So 323A of the Constitution empowers the Parliament to actually establish tribunals for adjudicating of disputes relating to service matters of the public servant. और इसी वजह से इसी के अंडर 1985 में फिर इसी को यूज करके in 1985 we formed CAT, Central Administrative Tribunal. CAT इसी को देख के बनाया गया. पहले 42nd Constitutional Amendment Act 1976 की वजह से हमने 323A और 323B को कॉन्स्टिट्यूशन में लाया, हमने कॉन्स्टिट्यूशनल अमेंडमेंट किया और फिर 323A के अंडर हमने 1985 में कैट का गठन किया, सेंट्रल एडमिनिस्ट्रेटिव ट्रिब्यूनल. कैट जो है ये डील करता है डिस्प्यूट्स जो सिविल सर्वेंट्स के हो, उनके डिस्प्यूट्स के साथ डील करता है. कौन से वाले डिस्प्यूट्स? डिस्प्यूट्स रिलेटिंग टू रिक्रूटमेंट के डिस्प्यूट्स, डिस्प्यूट्स रिलेटिंग टू सर्विस कंडीशंस, प्रमोशन, डिसिप्लिनरी एक्शन इन्वॉल्विंग गवर्नमेंट एम्प्लॉइज. इन सब केसेस को रिलेटेड कैट जो है वो देखता है. Then Article 323B, this article, it was also imbibed in the Constitution through 42nd Constitutional Amendment Act of 1976. ये जो 323B है, it allows both Parliament and the state legislature to establish tribunals for other matters, such as taxation disputes, such as industrial disputes, such as land reforms, such as election to local bodies, food या essential services का regulation, ये 323B के अंडर होता है. ये एम्पावर करता है ना सिर्फ पार्लियामेंट को बल्कि स्टेट लेजिस्लेचर्स को भी, क्या आप कानून बना सकते हैं विथ रिस्पेक्ट टू टैक्सेशन डिस्प्यूट्स. कानून को एडजुडिकेट करने के लिए ट्रिब्यूनल्स बना सकते हैं फॉर टैक्सेशन डिस्प्यूट्स, फॉर इंडस्ट्रियल डिस्प्यूट्स, लैंड डिस्प्यूट्स, election to local bodies disputes regulating that, and food and essential commodities regulation. इसीलिए 323B जो है ये प्रोवाइड करता है ब्रॉड कॉन्स्टिट्यूशनल बेसिस फॉर एस्टैब्लिशमेंट ऑफ ट्रिब्यूनल्स इन इंडिया. समझा? कुछ मेजर ट्रिब्यूनल्स इन इंडिया उनको देखते हैं. Major tribunals in India उनको थोड़ा सा देख लेते हैं. So to give you an idea, the major India has established tribunals in varied sectors, specialized areas में disputes को, specialized disputes को resolve करने के लिए. Most important is जैसे अभी हमने देखा था CAT, the Central Administrative Tribunal, which I just talked to you about. 323A के अंडर जिसको बनाया गया, इसको 1985 में बनाया गया एडमिनिस्ट्रेटिव ट्रिब्यूनल्स एक्ट के अंडर. ये एडजुडिकेट करता है डिस्प्यूट्स रिलेटिंग टू सर्विस मैटर्स ऑफ सेंट्रल गवर्नमेंट एम्प्लॉइज. ठीक है, सो कैट इन मैटर्स को देखता है. देन वी हैव अनदर कॉल्ड द NGT. दिस इज अनदर ट्रिब्यूनल दैट वी हैव. It's called the NGT, the National Green Tribunal. It was established in the year 2010 at 1985. NGT was established in the year 2010. ये handle करता है disputes को जो relate करते हैं to environmental protection or ecological conservation. So all those issues with respect to ecology and environment, they are specially dealt with by the National Green Tribunal, which was established in the year 2010. And this plays a very crucial role in enforcement of the environmental laws. Environmental laws को enforce करने में भी बहुत important role play करता है the National Green Tribunal, NGT. Then we have another important tribunal in India, the Income Tax Appellate Tribunal. Income Tax Appellate Tribunal, ITAT. And this is one of the oldest tribunals in India. मैंने आपको कहा था आज़ादी से पहले भी हमारे पास ट्रिब्यूनल्स थे. So this is one of the oldest tribunals in India. ये डील करता है with appeals relating to income tax का assessment और disputes income tax के. Income tax की disputes, whatever disputes, और उसकी assessment, उसके साथ डील करता है income tax appellate tribunal. Then we have the National company law tribunal, another very important tribunal, National Company Law Tribunal, NCLT, very much in news nowadays because of all the bank insolvency courts. ये deal करता है with disputes relating to corporate governance, insolvency, as I was telling you, or company law matters. ठीक है? So corporate governance को ये देखता है और corporate governance को adjudicate, very specialized area, and administration is undertaking such adjudication. So National Company Law Tribunal उन disputes को देखता है which are related to corporate governance, insolvency, company law matters. ये बहुत important role play करता है in insolvency and bankruptcy code of India. ठीक है? It is the appellate authority. They are given much power, so it plays a very important role under the insolvency and bankruptcy code. Consumer Disputes Redressal Commission. This is another tribunal. Consumer Disputes Redressal Tribunal Commission. Okay. ये जो Consumer Disputes Redressal Commission है, ये ट्रिब्यूनल जो है ये रिजॉल्व करता है डिस्प्यूट्स बिटवीन कंज्यूमर्स और सर्विस प्रोवाइडर्स. कंज्यूमर प्रोटेक्शन के लिए इसको लाया. So, and they exist at different levels. They exist at the district level, at the state level, at the national level. Okay? And enforcing consumer protection. So, this was about some of the important tribunals that we have in India. So, we understood tribunals in India. Advantages का Indian context में ये है कि ये फिर से discussed it, expertise लाता है, efficiency देता है, ये accessibility देता है, ये speed देता है. But then this criticism of tribunals as well. Despite इनके advantages, tribunals जो है, they have also faced criticism. ठीक है? जैसे independence concern. Independence concern. क्योंकि ट्रिब्यूनल्स ऑपरेट करते हैं अंडर एडमिनिस्ट्रेटिव मिनिस्ट्रीज, कंसर्न हर वक्त अराइज होता है रिगार्डिंग इनके इंस्टीट्यूशनल इंडिपेंडेंस का. फ्रैगमेंटेशन ऑफ जस्टिस, फ्रैगमेंटेशन ऑफ जस्टिस, proliferation ट्रिब्यूनल्स का जितना ये फैलते जाते हैं, इट हैज क्रिएटेड अ प्रॉब्लम ऑफ फ्रैगमेंटेड जस्टिस सिस्टम. अब ये केस वहां है, फिर ये वहां जाएगा, फिर दूसरा ट्रिब्यूनल है, फिर तीसरा ट्रिब्यूनल है, फिर ये है. सो इसने फ्रैगमेंट कर दिया है जस्टिस को. अभी तक हमारे पास सिंगल इंटीग्रेटेड जुडिशियल सिस्टम था, अब इसने फ्रैगमेंट कर दिया है जस्टिस को. अपील्स एंड डिलेज, अनदर बिग क्रिटिसिज्म. Appeals and delays. ऑल्दो ये ट्रिब्यूनल्स जो है ये क्रिएट किए गए थे रिड्यूस करने के लिए डिले को, मगर अपील्स टू हाई कोर्ट दे समटाइम्स लीड टू प्रोलॉन्ग्ड लिटिगेशन। फिर जो अपील यहां से डिसीजन आया उसके खिलाफ फिर अपील हाई कोर्ट जाती है, फिर जो पहले से केस चला था वो केस फिर से चलता है। तो इन दैट एस्पेक्ट इट क्रिएट्स डिलेज। सुप्रीम कोर्ट ऑफ इंडिया ने बहुत सारे इश्यूज के रिलेटेड इश्यूज में which are relating to tribunals, लैंडमार्क केस जो था इस कॉन्टेक्स्ट में वो है एल चंद्र कुमार केस। एल चंद्र कुमार केस, राइट इट, 1997 में हुआ था ये। एल चंद्र कुमार केस में कोर्ट ने ऑब्जर्व किया कि जो डिसीजंस ऑफ ट्रिब्यूनल्स है दे आर सब्जेक्ट टू जुडिशियल रिव्यू बाय हाई कोर्ट्स एंड द सुप्रीम कोर्ट। ट्रिब्यूनल्स they cannot completely replace the constitutional role of courts। ये सुप्रीम कोर्ट ने कहा इन एल चंद्र कुमार केस ऑफ 1997 कि डिसीजन ऑफ ट्रिब्यूनल्स जो है इट इज सब्जेक्ट टू जुडिशियल कोर्ट्स, जुडिशियल रिव्यू बाय हाई कोर्ट्स एंड सुप्रीम कोर्ट, और आप रिप्लेस नहीं कर सकते कॉन्स्टिट्यूशनल कोर्ट्स जो हैं। आप अपना कोर्ट बना के नॉर्मल ऑर्डिनरी कोर्ट्स जो कॉन्स्टिट्यूशन ने बनाया है उसको रिप्लेस नहीं कर सकते। तो इसीलिए ये दिस इज व्हाट द कोर्ट्स हेल्ड इन एल चंद्र कुमार केस इन 1997। इसीलिए ट्रिब्यूनल्स फंक्शन एज सप्लीमेंट्री इंस्टीट्यूशंस, सो दे आर नॉट द प्राइमरी इंस्टीट्यूशंस पर से, because the primary institutions are again the ordinary courts, the constitutionally established courts, original separate integrated courts. So tribunals, they function as these supplementary institutions rather than substitutes. So they're supplementing, help citizens get speedy justice, but they're not substituting. They are supplementing but not substituting. Remember this interplay of words, because UPSC most of the time likes to do that. It likes to interplay with words. Okay? So now, after having understood, this is our last lecture for administrative law. We gave it substantial amount of time. Tomorrow we continue with another topic. But let's try to understand now what is the role of administrative law in modern administrative state. What is the role that administrative law plays in the modern administrative state? अब हमने ये समझा है, इस क्रूशियल क्वेश्चन को हमने अभी तक समझा है इन आवर लेक्चर्स। 21st सेंचुरी ने विटनेस किया अनप्रेसिडेंटेड एक्सपेंशन ऑफ एडमिनिस्ट्रेटिव पावर। गवर्नमेंट्स आज रेगुलेट करती हैं ऑलमोस्ट एवरी स्फेयर ऑफ पब्लिक लाइफ, एनवायरमेंटल प्रोटेक्शन से फाइनेंशियल फ्रेमवर्क तक, वेलफेयर स्कीम से डिजिटल गवर्नेंस तक, एडमिनिस्ट्रेटिव एजेंसीज जो हैं they have become the primary instruments of governance. यही हमने अभी तक इन डिटेल डिस्कस किया है, and this answers the question. Get it? The role of administrative law, modern administrative state में क्या है? Now, let's try to understand the challenges as our last topic for today. Let's try to understand the challenges in modern administrative law. Challenges in modern administrative law. सबसे पहला चैलेंज, बहुत सारे सेफगार्ड्स हमने अभी तक डिस्कस किए हैं. डिस्पाइट ऑल ऑफ दीज सेफगार्ड्स, एडमिनिस्ट्रेटिव लॉ जो है ये फेस करता है बहुत सारे challenges in the contemporary world, जैसे expansion of administrative power. जैसे expansion of the administrative power. That is one of the biggest challenges of administrative law. क्योंकि modern governance जो है वो modern governments they exercise unprecedented regulatory authority. ये expansion increase करता है risk of excessive concentration of power administrative agencies के हाथों में. So that becomes one of the challenges that administrative law is facing. Bureaucratic discretion. Administrative officials जो हैं they often possess broad discretionary powers, जिनको हमने डिस्कस किया है, और अगर प्रॉपर सेफगार्ड्स नहीं हो ऐसी डिस्क्रिशन may lead to arbitrary decisions. Get it? So there's a challenge of that happening. Complexity of regulatory complexity of regulatory governance. मॉडर्न गवर्नेंस जो है वो इन्वॉल्व करती है बहुत हाईली कॉम्प्लेक्स रेगुलेटरी सिस्टम्स. इसीलिए इंश्योर करना ट्रांसपेरेंसी और अकाउंटेबिलिटी उस सिस्टम में खुद से एक बहुत बड़ा चैलेंज बन सकता है. वो खुद से एक बहुत बड़ा चैलेंज है. और एक चैलेंज है मॉडर्न एडमिनिस्ट्रेटिव लॉ का, और वो है ट्रिब्यूनलाइजेशन ऑफ जस्टिस. ट्रिब्यूनलाइजेशन ऑफ जस्टिस. एडमिनिस्ट्रेटिव ट्रिब्यूनल्स हमने अभी तक डिस्कस किए. सो वी सेइंग एडमिनिस्ट्रेटिव लॉ का खुद से एक बहुत बड़ा चैलेंज है, एंड दैट इज ट्रिब्यूनलाइजेशन ऑफ जस्टिस. Resorting to tribunals under the garb of administrative adjudication in itself becomes tribunalization of justice. So justice, it distorts into tribunals under the administration. ये जो expansion है tribunals का, इसने create किए हैं debates कि independence quasi judicial bodies, quasi judicial institutions में कितनी है. अगर administration ही एडमिनिस्टर कर रही है जस्टिस को, अगर जज भी खुद ही है, जूरी भी खुद ही है और एग्जीक्यूशनर भी खुद ही है, तो कितना इंडिपेंडेंट है. ये ट्रिब्यूनलाइजेशन ऑफ जस्टिस है. इंश्योर करना कि ट्रिब्यूनल्स रिमेन इम्पार्शियल और ऑटोनमस, इट रिमेन्स अ वेरी ऑनगोइंग चैलेंज. इट्स अ वेरी डायनेमिक चैलेंज. So modern governance state में power increasingly flow करता है through bureaucratic institutions rather than traditional legislative bodies. Administrative law therefore ensures that this power remains disciplined by the principles of rule of law, procedural fairness, or constitutional accountability. Get it? So, I hope that has cleared much of your concepts. Make notes, and I'll see you in the next lecture. Let's call it a day today. Thank you.